case briefs, and so much more. LSData's got what you're looking for.
The case of Lough v. Brunswick Corp. In 1996, centered on whether the use of an invention must be experimental and under the inventor's control in order to obtain a patent. Brunswick Corporation, also known as Mercury Marine, contested a court judgment that denied their motion to dismiss patent infringement claims involving a marine device called a stern drive. Inventor Stephen G. Lough had created 6 prototypes of the seal assembly designed to prevent corrosion, which were installed in various boats. The court examined whether the prototypes were used publicly or experimentally, taking into account factors like duration of testing, number of prototypes, records, secrecy agreements, compensation, and control over the testing to determine if they qualified as experimental. The case resulted in a jury verdict of infringement of U.S. Patent 4,848,775 owned by Stephen G. Lough, though Brunswick appealed the judgment. The court ultimately held that the district court's denial of Brunswick's motion for judgment as a matter of law was erroneous, and reversed and vacated the case partially. The court found that Lough's invention use was not experimental, thus denying him a patent and precluding any infringement compensation or further charges.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.